only violence that's happened in this case, Judge, is that the victim's advocate of this court's son attacked him at the barbecues in Chiefland.
Mr. Hales, I know you're making a face. On the court docket is Preston and Hales, 38-2023 DR 416.
You're about to see the live 5th court hearing in this injunction trial where I'm debunking all of LIEnette's lies. But Craig DeThomasis, this rogue judge who is out of control on the bench, he's demanded that every single council member be there. I'm represented by 3. 1 dropped out, Mark Feather. The man hates Feather for some reason.
Mr. Silverman, if you and your client could take the table to my left, your right. Shockett, the other one.
I already have a civil protection order against LIEnette and John CROOK, which this judge is failing to recognize, even though the state of Florida law says that it must be enforced, and so does federal law. Now she's attempting to get an injunction on me, which this judge has granted a temporary injunction based on her lie stating that Mark Feather, my previous attorney, tried to bribe her, so this never happened. I'm over $80,000 already in legal fees, and the ticker keeps going.
All right, let me set the record. We're here in the matter of Lynette Preston and Jeremy Brian Hales. This is
says my middle name, doesn't say LIEnette's middle name. Michelle, Alexis, Lacey, the list goes on and on. This woman has 39 known aliases thus far.
This is case 38-2023 DR 416. The matters for which are on the court docket include an amended order scheduling hearing, motion for sanctions from January 19, motion in limine January 24, motion to terminate deposition February 9, motion for protective order February 16, motion to dismiss February 18, motion for sanctions February 18 as well. Each of those are in the amended order scheduling hearing. There was a prior order scheduling hearing from February 20th that included all but one of those motions. The additional one was added so we can resolve it. The case is otherwise scheduled for final hearing on Friday, March 1.
All of these motions except for one to stop the deposition. That was Joshua Silverman, a defense attorney, a criminal defense attorney out of Gainesville. Why does LIEnette need a criminal defense attorney in a civil injunction case who's best buds with Craig DeThomasis? Ponder on that one for a little bit. All of these motions have been brought by my team, and DeThomasis has been ignoring them for weeks, literally ignoring them. And now, 2 days before the final hearing, he's going to have something to say about them?
Intervening and needing to be addressed also is a motion for stay of the trial court proceedings, filed today's date, February 28 at 9:55 a.m.
I'm going to explain exactly what he's talking about. I have filed 3 motions to disqualify Judge Craig DeThomasis thus far based on his bias, based on my fear of not receiving a fair trial under his presiding on that bench, and he's denied all 3. This man is beyond biased. This man cannot rule in this case. He's acted as a litigator, as a lawyer for LIEnette. He has belittled myself and all of my legal team. And so now what we've done is we've filed a motion to stay, or what that means is freeze this whole thing. It goes up to a higher court where DeThomasis is now under scrutiny to determine whether he truly is biased or unbiased. Now that can freeze this case. Nothing can happen in this case for months at a time. But I promise you, little foreshadowing here, this is not over by any long shot.
If I can, I'm going to just start on the right here. If you guys can just all identify yourselves for the record by stating your full name.
Doreen Euclides with Shockett Law Group, counsel for Jeremy Hales.
Jeremy Hales.
May it please the court, Randy Shockett, Shockett Law Group, Trenton, Florida, on behalf of Mr. Hales.
Joshua Silverman on behalf of the petitioner, LIEnette Preston.
LIEnette Preston.
Why didn't LIEnette say her name is Michelle? As a matter of fact, she just changed her Facebook profile to say Michelle Preston Sr. And she's told the world that she goes by Michelle, and that's always what she's gone by. She didn't say LIEnette Michelle Preston. She didn't say LIEnette Michelle Alexis Lacey, and the list could go on and on, Preston. Huh. Her real name is LIEnette.
All right, thank you. Give me just a second. All right, it would seem prudent for the court to address the issue with regards to the motion for stay. The court has received and reviewed the motion. As I understand the motion, there is an intent to consider or to file a petition for writ of prohibition. The court docket, which I, before coming in here just a little while ago, confirmed that there are no other pleadings that were filed since, but I just want the record to be clear.
Hearing number 5. First time LIEnette pulls a mask out. Remember, she's lied before and said she must always wear a mask everywhere she goes because her child has a life-threatening disease.
Is there a writ of prohibition that's been filed?
No, Your Honor, it's being prepared.
A petition for writ of prohibition?
A petition for writ of prohibition is being prepared. It's not quite ready yet. And the rules allow this, the case law allows us to advise the court ahead of time when there's such imminence coming with the first. So that's why we did that in exercise of caution. Mr. Silverman has agreed to it as well with continuing the TRO.
The writ of prohibition. We're asking the higher courts to actually prohibit Judge Craig DeThomasis ruling on this case because he has shown bias throughout it. And the TRO, that's the temporary restraining order, or in Florida, it's also called an injunction. And that's what's on me right now. Not based on what I've done, based on her lies and what she said my previous lawyer did.
Well, there may be consensus, but I want to hear from both counsel as to why the court should exercise discretion, because it's styled as a motion to stay, which is a proper nomenclature to use, but effectively it's also a motion to continue and delay the proceedings. And the totality of the circumstances would include, at a minimum, that the respondent has been represented by counsel for 3.5 months. For more than 2.5 of those months, he's been represented by 3 separate attorneys, 2 within the same law group, 1 from a separate law group, and has asked for a continuance and has been granted a continuance on November 29, December 1st, December 5th, January 4th, and now we're here again on a 5th motion to continue on behalf of the respondent, while at the same time the pleadings include and the history includes complaints about delay in the proceedings, among other things, and it's kind of inconsistent with asking, in effect, for another continuance.
This rogue judge is lying through his teeth. November 29th, I did not ask for a continuance. And he just went through all these dates saying the respondents asked for a continuance. It was him who was talking and let LIEnette take control of the courtroom. And you can see that court video on the Otter Creek playlist. It was him that said, we're going to come back and do this. I didn't ask for a continuance. On December 6th, I had to ask for a continuance because LIEnette, she falsely accused my lawyer, who is now a witness in this case, stating that he tried to bribe her. Within 24 hours, I defined new legal representation because now he's a witness. It was forced continuance based on what she said. She lied. She did. The next continuance was based on her dodging her depositions. The next continuance was based on her dodging the depositions. She went as far as lying, saying her mom died. Her mom is not dead. John Crook, he dodged the depositions. The next continuance, because some fool, this female who was never going to see a penny of her money back, gave her $7,000 to find a legal lawyer, a criminal defense lawyer. Why does LIEnette need a criminal defense lawyer out of Gainesville in a civil suit of an injunction? Go figure that one out. Well, maybe because she's a criminal and she's done criminal acts and she knows she has. So now there's another continuance. How in the world can this judge watch any of his hearings and claim he's not biased when he just said, I caused 5 continuances? When the reality is, I haven't caused any of them. I asked for one because of what LIEnette caused.
Your Honor, maybe heard on that point.
Yeah, I want, that's what I'm saying. I want to hear
okay.
from you on support for your motion to stay,
Absolutely.
which effectively continues the matter.
Okay, thank you, and we do disagree with the court on the characterization of how many continuances we've asked for.
Well, the
We
record is
totally-
the record, and you've got appellate review
Right.
if the court's wrong about that.
Here we go again. Count how many times Judge with a grudge, this is Judge Grudge, interrupts my legal counsel, but does not interrupt her legal counsel. The buddy that he used to be a defense attorney with. Criminal defense attorneys, buddy together, won't interrupt him, but interrupts my side over and over and over again, and somehow claims he's not biased.
Well, but
You've
the
got
record
limited.
reflects that on the 29th of November, this case started. At maybe 2 or 3 hours into it, the petitioner was in the middle of her case. There had to be a continuance. There had to be a continuance.
But your co-counsel represented to the court that he needed minutes to complete the entire case without additional discovery, without additional grounds for continuance, and then there were, and now 5, continuances despite those representations. And
This is like Jerry Seinfeld with Newman, his nemesis. Newman! Mark Feather! Your co-counsel. My co-counsel, actually, he withdrew because he could see how toxic this man was against him and how it's affecting my case. And here's what you're going to see next. You're going to see Craig DeThomasis tip his hat and let you know he's watching the videos, because he's going to state, and I know you take issue with me continuing to bring it up. I take issue with every single time you bring it up. You should be an unbiased, impartial. It's part of the job as a judge, Craig.
I know you take issue with the court bringing that up again, but that's the inception of the case, which would have been done by the court saying November 30, the next day at 9 a.m., we'll reconvene so that your client wouldn't have a temporary injunction necessarily hanging over his head. In fact, your co-counsel said he was so sure that with just a few minutes of time, the court would be dismissing this.
What Mark Feather said is this could be over and done if we look at the law right now. Even in LIEnette's petition, she states Jeremy tells all his fans never contact me. She admits it in her actual petition, and this judge does nothing with that admittal. Then Mark Feather says, can we have 15 minutes to bring the witnesses, Otter Creek's mayor and her husband, so they don't have to come back another day and be inconvenienced. He didn't say we were going to be done with all of this in 15 minutes.
And then the other side of you guys' mouth is saying we need another 5th continuance. So I don't understand how it could have been done in minutes, but now 3.5 months later, we're at a standstill or going backwards.
If I could continue without interruption, Judge, I really want to get there like you do. I want to just tell you what there's 2 different views here. The case had to be continued. I haven't seen an official transcript, but my impression of what I saw was, and I could be corrected, but I'm pretty sure Mr. Feather had witnesses here, and he said he would like them to go out of turn because she was in the middle of her case and it may take 15 minutes. I didn't hear him say, I need 15 minutes for my entire case. I thought he wanted to just have them go out of turn. But then there was this issue, it's regretful to watch what's going on here, December 1st, December 6th, or November 30th. I don't know what happened there, but it clearly got set, but it had to be continued until the 6th. So there was no request for continuance.
I found good cause for the continuance. So.
Want to talk about somebody double speaking both sides? The respondent has made all these 5 continuances when none of it is based off of me. Oh, well, I found good cause for the continuance. If you found good cause for the continuance, stop trying to blame the continuances on the respondent when it's all about the petitioner. If you can't tell, I'm getting heated in this court hearing right now more than any of the others, as he's blaming and blaming and blaming everything on me. And he wants so bad to put a permanent injunction on me and wants to shut down YouTube. And at one point, I even get yelled at.
I'm not,
Right,
I'm
but
not
we didn't ask.
reconsidering that. There was good cause in each of those. It
Again,
was
Judge,
granted.
I really would like to finish, because this is really important. No other continuance in this case. We're here almost March 1st. No other continuance of this case, and please let me finish, Judge. Nothing has been caused by us. Every single continuance in this case after December 6th has been responsibility over there. She missed her deposition on December 21st. She didn't show up for the 21st. Your Honor made a written ruling, required Mr. Hales to explain why he couldn't be there the next day. Orally, you did the same thing for her as to why we had to continue on January 4th. There's been no inquiry. Nothing's been shown why Cook's deposition was missed, why hers was missed, although you verbally asked her to do it.
He court-ordered me to prove that I had to fly to Ohio on November 30th after LIEnette just spewed nonsense for 3 hours almost in the first hearing, and then he had to schedule another day. By the way, that's not a continuance based on me, that's on her, LIEnette, okay? And so I show my plane tickets, and I show the court documents that are all stamped and they're notarized. And that court hearing happens on January 10th. It's a court hearing because they broke the violations. They continued to violate the civil protection orders. Then he verbally tells LIEnette, well, you need to show some proof that your mother died. Do you have like a gas station receipt? And we file a motion to make sure she actually proves it. He isn't denying. He's not even giving credibility to the existence of the motion. It's out there for nothing. He forces nothing on her. And yet, this is the incredible part. He literally thinks that he's unbiased.
So we got to the 4th, and it was not because there was a bomb scare.
That's part of to address the motions that are on the court docket today.
Well, you're asking for the history of it, so I don't want to be couched that we're the ones asking for all these continuances. We are here because of the behavior over there since December 6th. No other reason. Every continuance has been forced on us. So we're not here asking for another continuance. The reason why we're asking for this today is because it would all have to be redone if the first DCA issues a writ. Why waste everyone's time? Why do it? Why not just wait? We're willing to have the injunction remain in place until the date of the final hearing. So that's to prevent work that doesn't need to be done without objection, in fact agreeing we should wait. That's the basis of the request.
Here's what I see. A judge that got caught in another lie, and then my lawyer putting him back in his place as he continues to show and tip his hat that he's watching the videos, and as he continues to interrupt my lawyer, but not her lawyer. He's been put in his place with truth. He can dish out the lies, but he can't handle the truth when it's smack dab right in his face.
Anything further?
Unless
You
the
have
court
to respond.
You can, no, it's fine.
Okay. Mr. Silverman.
Your Honor, to be clear, my client does not agree to the granting of a motion to stay these proceedings. What I have clarified for Mr. Shockett and for the court, I did reply. I know it's unusual, but given the motion was filed this morning, I felt it best to offer a reply to the court. I did send an email to Ms. Hagan, copy to counsel. I don't know if that's been provided to the court, but what I can tell the court...
It is not.
What I can tell the court, my understanding is in federal court, which I don't practice in, they do a lot of advising the court by letter or email. I know it's not done in state court, but because of the late notice, that's the way I did it this morning. What I set forth in that email is that my client would not consent to a stay, but my client would consent to a continuance of all pending matters in this case, including the hearings that are set for today and the final hearing on March 1st with some caveats, and I will outline those, Your Honor. The first would be that the temporary injunction must be extended during any period of continuance and until the new final hearing date in this case. My understanding is that Mr. Shockett, on behalf of his client, agrees to that proposition. The second would be that if the First District Court of Appeal, or I guess presumably the Supreme Court if it got that far, were to grant the petition for writ of prohibition, my understanding of the law is that a successor judge has the ability to revisit any rulings this court may have made. However, as part of her agreement to a continuance of the pending matters, my client would insist, and again I believe there's agreement from that side of the aisle, that there would be a stipulation that the issuance of the temporary injunction will not, under any circumstances, be one of those rulings that is subject to review by a successor judge, if there is a successor judge, if a writ of prohibition were to be issued by the appellate court. Generally speaking, a party in litigation can waive any right, whether it's contractual, statutory, constitutional. There's a case directly on point. It's called Kilpatrick v. McCluth, and so essentially Mr. Hales would have to be waiving his right to have any successor judge revisit the issuance of a temporary injunction. The third would be that there would be no stay issued by this court. As I understand the rules of appellate procedure, the only stay would arise if the appellate court issues an order to show cause directed to my client to respond to the petition for writ of prohibition. That would be Florida Rule of Appellate Procedure 9.100H. And then the last thing I indicated was a caveat on my client's agreement to continue these proceedings is that by agreeing to a continuance, my client is not, I repeat, is not waiving in any way, shape, or form any arguments she may have either in this court or in the appellate court that the petitioner's, or rather the respondent's petition for a writ of prohibition is untimely or has been waived implicitly or otherwise, given the lapse of time since the court first entered an order denying a motion to disqualify the first time and the second time. So she's not waiving any of those arguments. My understanding is that Mr. Shockett and his client are in agreement with those provisions, and if that is the case, then for a variety of reasons, my client would be agreeable to continue today's hearings, to continue the March 1st hearing that's set for Friday, and to allow a reasonable period of time for Mr. Shockett and his client to file the petition for writ of prohibition with the DCA.
In other words, LIEnette, who claims she's paralyzed to her own home, which she does not have, she's living illegally in a shed with no occupancy permit, and shows up at town hall meetings even though she claims she's scared to death of myself and George, and she's there for an hour and a half, which she's now incriminated herself in that, wants that temporary injunction to stay in place, which literally does what for her? I have a civil protection order against her already. She must stay away, and she constantly breaks it and violates it.
I agree, concur with everything was said. He can make any motions he wants up at the first. That's true. He's not waiving anything.
What about the issue of the temporary injunction not being reviewable if it's remanded back?
We'll stipulate. No, the temporary injunction will remain in place until the date of the final hearing unless this court does otherwise. We're not going to challenge it. We agree that it will be in place until the date of the final hearing, whenever that is.
And so two things on that, Your Honor. One is, I'm okay with that. That's a slight tweak to what I had set forth. The caveat I placed on my client's agreement was that any successor judge could not revisit your decision to issue the temporary. The temporary would remain in effect through the final hearing. If the first DCA, for whatever reason, denies the petition for writ of prohibition, and this, Your Honor, remains on this case, I don't think that that provision needs to remain necessarily in effect. If they file an appropriate pleading and ask you, Judge DeThomasis, to reconsider the temporary, I think that you should be able to do that. What I am trying to avoid, however, is a new judge coming in and vacating the temporary and potentially prejudicing my client. She's not going to agree to continuance under those circumstances.
We will stipulate that,
The
Judge.
second thing I would ask is that I would ask if the court is inclined to go along with the party's agreement to continue matters, that Mr. Hales be placed under oath and that the court conduct a colloquy with him so that his agreement to these provisions is placed on the record under oath.
It's fine.
What everybody's agreeing to is Judge DeThomasis is so out of control that we're going to wait until the higher courts actually evaluate him and either boot him from the case or bring somebody else into the case, or he still gets the case. But during that time, I have a temporary injunction on me. Temporary injunction is 15 days, unless a judge extends it. This judge is going to attempt to extend it indefinitely. By definition, that's permanent, not temporary.
So, Mr. Shockett, you wish to be heard on the issue that, in effect, Mr. Silverman is characterizing that I should effectively view the motion to stay as a motion to continue rather than a motion to stay, and in effect deny it as a motion to stay the proceedings, but to continue the evidentiary hearing scheduled for today and the final hearing scheduled for Friday.
That's not what I heard him say.
No, that's what I heard.
I'm asking, since, again, my client will not agree to a stay, I think that has certain legal implications. My client will agree to continue everything.
Everything.
The only stay would occur if the appellate court issues an order to show cause or otherwise issues an order directing this court to stay the proceedings, is the way I interpret the rules of appellate procedure. So I have no objection to the court accepting and treating the motion for a stay as a motion for a continuance. If they want to or tennis amend that motion to be a motion for continuance, I would have no objection to that. But again, for the record, my client objects to a stay but not a continuance.
Right, and that's why I'm raising the issue, and I initially couched the stay as effectively a continuance. Mr. Silverman is saying it ought to be amended and be handled as a motion to continue and not a stay. The stay implicates issues of jurisdiction, and I can't confer jurisdiction or provide jurisdiction, as the case may be. It's set out by rule.
But, Your Honor, you have jurisdiction during a pending petition. You have jurisdiction. That's in the motion. You have jurisdiction even if the first ECA is considering. Now, they could issue an order to show cause. That's true. But what we're saying is, and it's really substance over form, it doesn't matter what you call it. We're asking that no further proceedings, absent emergency, unforeseen things, all pending matters that are pending now, be continued until the First District Court of Appeals rules on the petition. Obviously, you have jurisdiction to hear, God forbid something happens. You still have jurisdiction during that, during a pending petition. The court loses jurisdiction during a pending appeals. That's true. Even non-final orders if they accept jurisdiction, but this is not jurisdictional. A petition for a writ of prohibition is an original proceeding in the appellate courts. It's not what we think of as an appeal. So this is necessary to some extent. But you have jurisdiction, concurrent.
So here are the totality of the circumstances that are of concern to the court. And proceeding under 9310, the subsection A, the decision to stay is discretionary to begin with. And thus, the totality of the circumstances leading to the court's determination are relevant for any reviewing court to consider. And that would include that counsel has been representing the respondent since November 13th and continuously for nearly 3.5 months. Respondent had counsel in place within 12 days of being served. Regardless of whether you are reluctant to call them motions to continue or why they were motions to continue, nonetheless, the court found good cause on prior occasions, including November 29, December 1, December 5, January 4, and now here we are again on respondent's motions to continue.
Again, court found good cause for these continuances that LIEnette caused. But yet, in the beginning, DeThomasis wants to attack me. Your client, the respondent, caused and requested all of these. I don't get this man. He wants to attack me for it, and then he says he found good cause for it. Now he says I'm asking for another continuance. I'm not. I'm asking for a stay. Silverman and LIEnette are asking for a continuance. Again!
There was a hearing on November 29, at which time the respondent's counsel said the case could be concluded in minutes. The court offered the following day to bring it to a final resolution. That was denied. Counsel for the respondent represented he would be in court the following Wednesday to conclude the proceedings. He failed to appear, and instead successor counsel came in, and I started that proceeding by saying, Mr. Shockett, I'm going to give you the continuance if you needed to get prepared. Number one, because I want you to be prepared. Respondent's entitled to counsel of his choosing and to be prepared. And number two, because there was a change in circumstance in that a temporary injunction, which had previously been denied by this court, had been entered.
Does he think we all have dementia or something? This is hearing number 5. Hold a second. He must have seen LIEnette's deposition. Now he knows. Her brain doesn't work with dates and times or remembering anything that incriminates herself.
Then we came back by agreement January 4, at which time, among other things, there was a bomb threat, which, needless to say, cleared the courtroom and thwarted the proceedings from continuing any further down the path. On that same day, we agreed to come back on January 26 for final hearing, in part due to the bomb threat. Intervening before the January 26 was the petitioners, fairly new at that time, counsel's motion to continue, which was then granted, which brought us to today's date, scheduled February 28. There have been complaints and pleadings filed with the court about the length of time it's taken, and now we're asking for another continuance. And I gotta question what really is the design and the desire when it would be inconsistent to complain about the length of time and at the same time ask for a fifth continuance.
The design and desire, the design is to have him evaluated by a higher court because he's biased. The desire, that he's off the case and off the bench for good. And there are some individuals who can make that happen. Florida legislature, and you can contact them. If you see a problem with any of this, you have the legal right to contact them. Governor DeSantis, you can contact him. This is not okay.
Additionally, there's been criticism and complaint and in pleadings before this court about the injunctive relief that as a matter of law, if a continuance is granted under the subsection statutory section, it must be 784-0485 subsection 5A, 5B, 5C. If there's good cause, the extension of the injunction that might be in place will also stay in place. This court entered an addendum that the respondent accepted. I read what I proposed as the addendum on December 6th. Counsel for the respondent said no objection. I then said, take a few minutes. I'm going to go and reduce it to writing. I'm going to hand it to you in writing. Please review it. Have your client review it. Both respondent and counsel said no objection.
I object to all of it. I object to even being in court in this. This is frivolous. It's ridiculous. I never said no objection. Now, my counsel said no objection, and that's what I pay my counsel for. My counsel is looking at the long term, the long game of what's going to be accomplished in this. But I'm against all of it. None of this ever should have happened. He took away my First Amendment right, my Second Amendment right, and it goes on. Fifth Amendment right, due process. Oh my goodness, the things this man has done to me is unconstitutional. I object to all of it.
Which is an agreement, a stipulation to those conditions. Yet, it keeps coming up in subsequent pleadings.
No, what keeps coming up is, on November 29th, your co-counsel, Mark Feather, said this could be done in 15 minutes.
As a complaint, and I understand that because he is restrained. I then, because of the ruling on December 29th, the first appellate court ruling since the October 2021 statutory change in the language, adding 6 words, and if you read footnote number 1 of the previous DCA, second DCA opinion, it is of substance and materiality. This court modified the addendum from this court's perspective, more narrowly placing the restrictions, but nonetheless, there were restrictions without opposition.
You just heard Judge Craig DeThomasis, trying to cover his backside. What he did was illegally took away my First Amendment rights. And now he's saying, and then I was so gracious, I gave them all back to Jeremy because that's the law. It's in the Constitution.
There was the first motion to disqualify on December 21, order denying 12/26, no writ sought. There's a second motion to disqualify, February 11, order denying February 14th, no writ sought. Despite the order denying the disqualification and no writ sought, and despite the fact that the writ of prohibition is the recognized proper avenue for immediate review of whether or not disqualification is an appropriate remedy, additional motions were filed on February 16th, 2 on February 18th, 1 on February 27th, all on behalf of the respondent. Additional requests by counsel for the respondent for hearing time. The court scheduling the hearing time for today. from the court's view, contrary to 9.100, which requires a writ to be filed timely to prevent further court action. And then 1 week prior to the hearings being set on the motions that were filed after the second order denying disqualification, counsel for the respondent files a third motion to disqualify. Order issued today's date, February 28th. Now, the motion to stay amounts to saying we plan in the future when we get to it, because, and I'm not belittling the intervening other requirements that counsel has both with court and outside of court, but saying I'm going to get to it, but I need more time to get to it because I got other more important things to do than my client's cause in this case, so let's continue it again. It says that there's already been a ruling creating further grounds for disqualification, so another motion for disqualification is likely to come, or a writ, I don't know which, but you've had time to do each. The rules require it to be timely. The
Your Honor,
court's
may I be
investing
heard?
itself again, and you're asking for a continuance, but you don't want to call it a continuance, you want to call it a stay. And the court still, because it's effectively a continuance under 2.545E, needs to find good cause, and I'm having a hard time do so.
May I be heard, Judge?
In a second, yes, you can. The inconsistencies that have been pled and pleaded by respondents' counsel are numerous. That's part of the totality of the circumstances. Whether it's I only need a few minutes, but now we've got 3.5 months and it's not enough. Whether it's complaints about additional delays, but now we're the party seeking a fifth delay. Whether it's complaints about the injunctive relief that counsel for the respondent and respondent himself agreed to on December 6th, and then again in January when it was amended and more narrowly focused.
As if Judge Grudge gave me any option to disagree.
There are 6 pending allegations for violation of the injunction, one implicating this attorney of record for the respondent, case 38-2023 MM497. There have been findings about violations of the Florida Supreme Court Order AOSC 1122, the 8th Circuit Administrative Order 1.14 V2, Rule of Procedure 12.310 B4, and basically I'm being asked to delay a case again because we intend in the future to take further action by filing a writ, which we didn't timely do yet, and we say that we're going to. And I'm having a hard time determining that to be good cause for another continuance, a fifth.
Okay, may I be heard? May I be
Hashtag buckle up. I think I'm about to get in trouble.
heard?
Yes, sir.
Okay, so the timing of a writ of prohibition is when it's as soon as practicable. And Your Honor, we have a fundamental disagreement here. We feel it's very clear that when an order denying a motion to disqualify a trial court judge in this state, the law is very clear. It shouldn't take issue at all. It should simply say, and I think it's even in the bench bar handbook or the bar handbook, for the court, it says simply say it's denied as legally insufficient. When there's so much more in there, there's case law that says that creates an additional ground.
File the writ. We'd
Well,
be
no,
out of
no,
here.
no, that's not the remedy, Judge, because you have to give the court a chance to rule on it. So we are filing a writ now based on the first 3. The problem here is the Hobson's choice, because he does have a feeling and a belief. He has a right to take it up to the first. He has a right to file a motion to disqualify. And so his Hobson's choice is basically this. It's not untimely. Even the second one's not untimely. Even the first one's not untimely given the history of this case. And we are not. This is really the second time we've asked for a continuance.
Explain what you mean to me by the first one. The
first
first order
motion to disqualify.
denying disqualify was not-
Around Christmas time. And we thought the case would be over January 4th. Little did we know what eventually occurred every time since then. But they keep on causing continuances, and we're getting blamed for it somehow. They're the cause ever since December 6th. So
No,
what's the
wait a
problem?
second, wait a second. I want you to explain that. Mr. Shockett, I'm not cutting you off as much as I'm giving you, I'm inviting you to explain that position.
Okay.
There's an order disqualifying, you've got a remedy to seek a petition for writ. You don't, but what you're saying, I just want to make sure I'm understanding this, is that,
I have the case law.
no, it's not really case law. I'm not taking issue with the law. What you're saying is factually, your determination was, if we can get to January 4 in anticipation of that being the final hearing, let's just have the judge that we move to disqualify stay on the case and hear the case?
Frankly, Judge, he changed his mind based on what happened January 4th. We seem to have a ruling saying, you know what, I required him stringently to provide proof of reason for the continuance. And you orally that day ordered her, no compliance. In fact, I have a pending motion to compel discovery that you still haven't ruled on because she failed to appear in December for the depositions that you told her I might grant fees against you. You told her to provide proof. She's provided nothing. That's still a motion that's outstanding.
I think for today.
No,
To be heard.
no, it was filed, it was not filed for today. It wasn't, it still hasn't been ruled on because we're still waiting for her to comply with your oral ruling to provide proof of why she didn't show up December 21st. We've seen nothing. So every continuance is because of that. We don't want to pin it. I understand you, but we're given a Hobson's choice, which is basically have this temporary injunction continue to exist, or have this trial exist when we have discoveries issues and we have a court which he feels is not able to be impartial. So this is the Hobson's choice. He's accepted the other end of it, which is, okay, we'll have the temporary injunction. Let's see what the first says. We have agreement on both sides on this. It doesn't
Well, there's
seem-
not agreement. You
Yes.
want a motion for stay, he wants a motion for continuance.
That's a term of art, Judge. It's the same effect. The
And-
same effective remedy is you have jurisdiction. Nobody here, we want to continue the pending motions, including my motion for fees, which hasn't been noticed. I've asked, again, that's hanging since December. We want it, you have jurisdiction. Everything, any concerns you may have about what happens to her is still sufficient. The only violence that's happened in this case, Judge, is that the victim's advocate of this court's son attacked him at the barbecues in Chiefland. And there's a case on that. That's the only violence that's
How do
occurred
I-
because
how
of the
do I
case
know?
to him, not to her.
No, but, Mr. Hales, I know you're making a face. How do I know that unless your attorney just told me it about 14 seconds ago?
Oh, he knows. The entire court staff is watching every video. And as a matter of fact, it was pretty evident on the court staff's faces that he just lied straight-faced to me again. And it doesn't end. To be continued.